So the whole idea here, I think we heard a lot those past 2 days about a lot of very important moves that the sector is going through. We heard about automation, machine learning. We heard about app integration, about do it for me, do it with me models. We heard a lot about what the consumer wants and what he doesn't want, what SMBs are looking for, and so on. And I think the common denominator behind all that is presumably data. And the way you are managing data, the way you are using data, reusing it, revamping it, or whatever. And the way to link, of course, we have to link that. If we take the legal and regulatory perspective, it all sounds awesome. I mean, all the different presentations that we see, they really sound awesome and very interesting. My first question would be, how legally will it be linked to the usage of data? And then I'm going to throw away the big ball in the water, which is the words you all know, safe harbor. I guess you're all aware that the European Court of Justice just invalidated the safe harbor agreement a few days ago. And a lot of you are probably relying on American company exchange of data with American companies, be it for cloud services or whatever. So now we are facing a challenge of the gray zone. We don't really know what's the practical impact of the ECJ decision is going to be. So I'm just going to ask our panelists there if they have any comments to make, maybe beginning with you, Kostas, or I don't know.
Well, I can start with the safe harbor.
Yeah.
As you can imagine, well, many companies were expecting that the European Court of Justice might go as far as invalidating the agreement, but what came as a surprise was the argumentation of the court, because with the arguments the court used, it will be very difficult for any alternative mechanism to be in place, because right now a company can transfer data using binding corporate rules or using standard contract clauses, but this mechanism can still be declared invalid in a future case by the court. And this is where we stand. I think it's a big headache for any company who has been using safe harbor. Where do we stand now? And it's no surprise that no one has the answer. We're all waiting for the European data protection authorities to provide some guidance, because what will happen now is it will be for the European data protection authorities to enforce the legislation when it comes to transfer of data to the US. So any authority that receives a complaint by any user asking the authority to investigate the transfer of his data to the US can actually declare this transfer illegal. So there's a lot of uncertainty. And of course, data protection authorities have different resources, different approach to data protection, and we might end up with 28 different approaches to enforcement right now. And this is why it's important that the authorities, with the European authorities, the European institutions, come up with a coherent approach that will make the life of all companies much easier. Otherwise, it's really, it's a big headache right now.
So I have a question. Under the ruling, which I didn't read entirely, but I know something about, an individual can bring, or maybe this is the larger data protection framework, an individual can bring a claim like Schrems against a particular company, and there's no preemption. They can just say, I don't want my data to go to the US because of NSA spying or whatever, and the Data Protection Authority has to hear that claim. Is that correct? Is that a correct understanding?
This is where we stand now, like as after the ruling.
Today, yes.
Exactly.
Okay. Then the second point is, it seems like any transfer of data between Europe and a European country or citizen of Europe and the US is invalid now. That you simply cannot have any transfer of data between companies in the two jurisdictions. Is that a correct understanding?
More or less. This is the worst case scenario, because already you have some of the German data protection authorities who came out publicly saying that all the other mechanisms, like standard clauses, are also invalid.
Everything is invalid.
So this will be the worst case scenario. We'll see what will be the final conclusion of this discussion among the authorities, but it's quite worrying that some of the authorities, especially in Germany, follow this approach. Whether this will be the pan-European approach, if there will be one, that remains to be seen. I think we'll know next week or by the end of the month.
So let's say that I'm Google or I'm Facebook, and I now set up a bunch of servers in Europe to retain European user data entirely within Europe. What about, so Kimberly and I exchange email, and I live in the US and she is in Czech Republic. How does that work?
I think it's really going to be different if you think it from the private point of view or from the business point of view. So what's unclear, and as Kostas said, for the moment we don't know what the common denominator at the EU is going to be, if there is going to be a common denominator, because this is another possibility. You all know that the European Commission, well, the European institutions are still debating on the data protection regulation, and of course the safe harbor judgment is going to have an impact on the way they go through with that. So the first thing is there going to be a common denominator in Europe? We don't know. And the second thing is that you're not going to scrutinize the same way private correspondence between Kimberly and you or business correspondence between LSA and Cinda, let's say. It's going to be different.
That's the question. I mean,
But Google has if I use a Gmail address, which is one of my email addresses, and Google has access to that, and presumably the U.S. government, the fear is that the U.S. government will peek into our email. We conspire all the time to overthrow different regimes around the world, so they're monitoring that my email communication quite closely. But I mean, it doesn't matter because the intermediary is Google or Facebook. And so maybe there's official business correspondence and maybe it's just a personal communication, but Google or Facebook or whatever the intermediary would have access to that.
Well, they would, and you brought the example, what would happen if they just held all the data on European servers. This could be a solution, and actually some companies started already some time ago to offer European-only data storage to avoid this situation. But, and this is the big but, there is a jurisdiction in the US that the US company, even though it's based in Europe, is under US jurisdiction. So the US could order a company that has a US mother company to open the data up to the US government.
A few words. Just one point which might be obvious, but it's important to say it loud and clear. There is no such thing comparing United States and Europe as a whole, because at the moment there is no single data protection regulation which is valid on the EU. It is pending for 3 years already, as far as I know, because I'm part of the negotiations, unfortunately. So it's 3 years being discussed. It's in a trilogue at the moment for the past 4 months, as far as I can remember. It will probably be in a trilogue up to the end of this year, and we will see what's going to happen the next year. And at the moment, there are 28 different regulations in Europe regarding the GDPR. So the proposed solution, you mentioned it, putting servers of Facebook or Google on European soil is not a solution. It's a solution for one country where you will have to apply for the regulation that is being pushed in that state, in the country, but you still need to be aware that there are 28 regulations that need to be complied with depending on your user base. So that's an important point.
So I'm sorry, I don't want to monopolize the conversation. Does anybody else want to get involved? Okay.
Raphael, sorry.
Thank you. Hello, good morning. I have two questions. First is from the citizen point of view. Should all the watchdogs and regulatory officers accept all the claims if tomorrow everybody complains because it's not anymore valid, the decision 2000, and then first if the watchdogs should accept and analyze and make a decision about this in each country, and second, if I am allowed to ask for damages or punitive indemnity to the company in case that finally it is decided that it's not illegal? Because the third question is it the decision, is it applicable from now on? I mean, there is no effects in the past?
Actually, yeah, and actually that was the major question. I happened to discuss that with the Commission over the last week, the European Commission, and the big question that came out of the ruling is that in similar situations, the European courts have actually come up with temporal limitations, at least allowing the judgment to come into effect within, say, like, I don't know, 2 years' time, a year time, or something like that, to allow for breach time, actually, what will happen in the meantime. But unfortunately, in that situation, the judgment is effective immediately. As to your question on damages, I have to say that I'm not a privacy lawyer. I think that Kostas is probably more well acquainted with the issues, but I believe that it would depend on the local, the national legislation, at least at this stage. Now it's another situation what is going to happen when the regulation, the proposed regulation, will come in effect.
And to answer your first question on data protection watchdog resources, I mean, if suddenly all the citizens bring claims to the DPA to say, yeah, my data has been abused and so on, they're just going to burst. They can't face it because in some of the countries it's like a small team, you know, sitting at the end of the corner of some former ministry, or so. I would say, yeah, class actions. If they come through in the data protection regulation, are probably going to be the step forward.